Constitution of India. Part 3. Fundamental Rights. Right to Freedom. Article 22. Protection against arrest and detention in certain cases. 1. No person who is arrested shall be detained in custody without being informed, as soon as may be, of the grounds for such arrest. Nor shall he be denied the right to consult, and to be defended by, a legal practitioner of his choice. 2. Every person who is arrested and detained in custody shall be produced before the nearest magistrate, within a period of 24 hours, of such arrest excluding the time necessary for the journey from the place of arrest, to the court of the magistrate, and no such person shall be detained in custody beyond the said period, without the authority of a magistrate. 3. Nothing in clauses 1 and 2 shall apply to any person who for the time being is an enemy alien, or to any person who is arrested or detained, under any law providing for preventive detention. 4. No law providing for preventive detention shall authorize the detention of a person, for a longer period than 3 months. Unless, an advisory board consisting of persons, who are, or have been, or are qualified to be appointed as, judges of a high court, has reported, before the expiration of the said period of 3 months, that there is in its opinion sufficient cause for such detention. Provided that nothing in this subclause shall authorize the detention of any person, beyond the maximum period prescribed by any law made by Parliament, under subclause B of clause 7. Or, such person is detained, in accordance with the provisions of any law made by Parliament, under subclauses A and B of clause 7. 5. When any person is detained in pursuance of an order made under any law, providing for preventive detention, the authority making the order shall, as soon as may be, communicate to such person the grounds on which the order has been made, and shall afford him the earliest opportunity of making a representation against the order. 6. Nothing in clause 5 shall require the authority making any such order, as is referred to in that clause, to disclose facts, which such authority considers to be against the public interest to disclose. 7. Parliament may by law prescribe a. The circumstances, under which in the class, or classes of cases, in which, a person may be detained for a period longer than 3 months, under any law providing for preventive detention, without obtaining the opinion of an advisory board, in accordance with, the provisions of subclause A, of clause 4. B. The maximum period, for which any person, may in any class, or classes of cases, be detained, under any law, providing for preventive detention. And, C. The procedure to be followed by an advisory board, in, an inquiry, under, subclause A of clause 4.